Okay, I think I'm recording. My name is Kenneth Ehrenberg. I'm a reader in the law department or the School of Law at the University of Surrey and co-director of the Surrey Center for Law and Philosophy. I have a paper here called Uptake Grounds Legal Status, but be careful whom you tell. I had a previous recording where I gave a 5-minute overview of just like 2 or 3 little things that would be helpful to know as a groundwork. Even if you didn't hear it, it's not that important. This outline that you're seeing now, hopefully you can see it, is the whole presentation. I know I only have 20 minutes, so I'm going to probably just jump right in. But one word of I guess, preface here is that this is a new thing for me, and I very much appreciate your tolerance here, but I feel like this paper is very unpolished for a conference paper for me, and I'm looking for a lot of feedback because I'm not exactly sure which direction to take this. I think my intuitions here are basically the bold statement, but I'm also thinking about which direction to develop it a little bit more. It's still a very much work in progress. And I guess I'll call your attention to those issues as I come up. So the first point is that, it's about law, and we pretend law into existence like a fiction or a game, and it's mind dependent, right? So obviously it's mind dependent. We create it. It is what it is as a result of our creation. I think no one would really deny that. Even people who don't necessarily think that law is completely explained by what we've made. It's like a fiction or a game in that it's mind dependent, and its reality is it's a reality that we create in order to do that. People are probably pretty familiar with this in this context, social ontology being what it is. It's a kind of, I'm emphasizing the creative aspect, the created aspect of law. And that the fact that we pretend it into existence doesn't undermine or hamper that existence in any way. I mean, following Searle here, thinking about, money, it's just a medium of exchange that we've kind of created socially, and yet it's still really, it really has the value it has because we've imposed that value on it. Now, of course, law is an institution, making it more a product of pretense than other kinds of tools. I think of law as a kind of tool. Elsewhere, I've argued that it's an institutionalized abstract artifact, following Thomason in terms of artifacts there. But that it's an institutionalized abstract artifact, meaning that it's an institution, and artifacts are a subclass of tools. Most tools probably have more physical reality to them. Institutions don't in general. So we might say that they're also kind of created through this kind of pretense process. Institutions, number 4, are systems for creating and deploying artificial statuses that purport to change people's reasons for action, at least within the ambit of the institution. That's just how I understand institutions, following Searle there. I explained that in the preview video and stuff like that. But that implication of that for legal statuses is that legal statuses are therefore understood in terms of their functions, right? The idea is that, like any tool, we use the tool in order to accomplish something. So we're changing those artificial statuses. We're creating and deploying those artificial statuses in order to change people's reasons for action in a certain way in order to accomplish something. And in general, the way we're doing it is we're creating or altering and assigning rights and responsibilities. I mean, Searle calls them deontic powers, but basically what we're doing is we're creating new contextually bound rights and responsibilities and assigning them. Could be to other people, could be to events. Events could have legal status, could be to objects. Objects could have legal status. Think of, statuses like, for example, what it means to witness a will. When you witness a will, you are taking on a responsibility to affirm that the will was executed in your presence. To be a legal guardian of a minor is to accept responsibility for the care of that minor and possibly for some of her actions, perhaps in the form of having liability for damages, but also a right to direct her schooling and medical care and things like that. So all of these things are different kinds of statuses that create or manipulate rights and responsibilities within the context of the law, within the context of the institution. So here's the main claim that I'm trying to push for. I think most of that probably isn't going to be so it's not going to be so controversial yet. It's the next part that's going to be controversial, the second part of this claim. So the number 5 is the main claim of the paper, that all artificial status depends heavily upon intake. And here I'm talking about legal status, but that, you know, basically legal status depends heavily upon uptake, excuse me, meaning acceptance or internalization of some kind in order for it to work. But the more that we draw attention to this fact, the more we threaten its ability to succeed. Now, I don't think that's the second part that's really the main thrust of the paper. I don't think I've necessarily gotten it there yet, but I think I'm trying to call our attention to something with respect to that. So my aim is merely to illustrate this right now. The first claim is not, as I mentioned, controversial, likely, probably not so much, especially in this crowd, but still needs some support to lay the groundwork in order to make the second one. Okay, so if people generally ignore, just to support this idea of status depending upon uptake, if people generally ignored the purported status creation, it would never get beyond mere pretense, right? It would just be that mere pretense if everyone just ignored it, other than the person who was pretending, right? If only the person assigning status believes it to be reason-giving, then it would not generally change others' reasons for action. That's another point, right? I mean, if it's an artificial status, which means it doesn't already have a pre-existing set of rights and responsibilities attached to it outside the context of the institution, then there would be no reason for anybody other than the person making it up to think that their rights and responsibilities are changed by that status. So somebody else has to believe it. There has to be another person, at least to get the ball rolling, to go along with that first person's claim to manipulate rights and responsibilities by assigning an artificial status. So C, to distinguish from a mere flight of fancy, institutions have to be social, and hence there must be some uptake of some kind, right? So there has to be some uptake in order for it to even become social. In a way, these three claims are kind of saying the same thing, but they're trying to say the same things in ways that'll, you know, get the ball rolling and make it clear. So 6, institutions and social facts more generally depend heavily upon the first follower, which is what I just said, the first person to uptake the new reality it represents. I remember a TED talk that I watched online at one point, which was, I think, by a social psychologist or an anthropologist or something like that, and he was talking about how important that first follower is, that the leader, here he was talking more about leadership, but that leaders are really made by that first follower who gets the ball rolling. And there's this great video at this, you know, some kind of outdoor concert where one guy gets up and starts dancing, and for a while no one else is going along with it, right? But then somebody else starts to follow him and do the similar dance or do some dancing as well. And then all of a sudden, all these other people are dancing all over the place, right? So you can, in retrospectively, say, oh, wow, that guy led the way. He was the one who got it started. But really, the key was that second person, because the second person was the person to really get going with the uptake and say, oh, wow, you know, that's a great example. I want to follow that example. So in the context of legal institutions, we would say the second person is the person who listens to the initial legal, you know, directive or something like that, or the initial creation or deployment of status, and says, I agree with that, I believe it, I go along with it, I believe it to be reason-giving for myself, or at least believe it to be reason-giving for other people, even if it doesn't apply to myself. So then the question is, what kind of uptake are we talking about? Now, usually, we understand uptake as some sort of acceptance or internalization, some sort of psychological state. I'm a little bit on the fence about this. It may be possible for everyone simply to act as though they accept the status as reason-giving without actually having to have that internalization. I call this as-if uptake. It's not really uptake, it's as-if, because they don't actually have the requisite psychological state. My evidence for this comes from a guy named, I think it's George Kafka, a legal system in which everyone but the dictator acts out of fear would still be a legal system. I mean, he doesn't necessarily claim that. He's talking in terms of Hobbesian ideas of political philosophy. But the idea would be that if everyone's acting out of fear, they're not really seeing the law itself as reason-giving. Think about this for a second. If the only reason you had for obeying the law, you wouldn't really be obeying it then, is your fear of punishment, well, you already had the reasons that you had before to avoid the unpleasantness that would be associated with punishment. You're just getting information from the law about what best way to do that. How do I avoid punishment? You're not getting any new reasons from the law by doing that. I already just don't want to go to jail. I don't want to pay fines. I don't want to lose my life or be, you know, physically punished in any way. So those are already things I had reasons to do. I'm just getting information from the law about how to do that, right? So I don't get any new reasons from the law that way. So if you're merely doing it because of fear, all your reasons are coming from your antecedent prudential considerations. And yet, the claim could be that it's still a legal system. It could still be a functioning legal system if everybody acts that way. So that would seem to suggest you don't need actual psychological uptake. You could just have as if uptake. I'm not yet sure if psychological uptake is necessary to generate the problems that I'm talking about here, and I have to think some more about that. So number 8, the grounding that uptake gives to legal status extends to legal meaning. Here's where we're starting to move into, the kind of more, this is maybe a little bit more controversial or a little bit less obvious part of the paper, right? That the legal status of things, right, also applies to their legal meaning, right? When we start thinking about whatever you want to think about legal meaning, whether the semantic content of the legislation or of the judge's directives or whatever it is, that meaning in terms of what we're supposed to do is related to the reasons we get. If we're getting reasons, we have to understand what those reasons are and what they're reasons to do. And that's the legal meaning of the texts or of the judge's pronouncements. Yet that status is attaching to that legal meaning, right? The status is this reason is a legal one. That's a kind of legal status, right? So that's one of those contextual statuses that you get. And that requires certain uptake as well. So the grounding that uptake gives to legal status extends to legal meaning. So law can alter or circumscribe non-legal semantic meanings for application within the law, right? I can say in the legal context, marriage means this, or in the legal context, a contract is this, or a will, or something like that, right? So those things may have non-legal meanings, but the legal meaning is something maybe a subset or a potentially different understanding of those terms, and the law can alter that, and that's part of its way of creating and deploying statuses. So for legal status to accomplish its purpose, legal texts have to be interpreted in order to be applied. Even the most detailed of legal definitions that you might get, let's say in the beginning of a piece of legislation about what the terms mean, can fail to catch certain situations or dispute that need legal settlements. You might fail to catch some understanding, and therefore you'd need to have some kind of interpretation, not in every case, right? There are what we call hard cases and what we call easy cases. The easy cases, everybody understands what it means and how it's supposed to be applied. Hard cases are ones where it's not clear how the law is supposed to apply to a new situation or to one that maybe wasn't thought of or something like that. And so those are ones in which you're going to have interpretation. So it's in the nature of law that you're going to need to apply the texts, that you're going to need to interpret them in order to apply them in many cases. So I have an example in the paper. This is the example that's used by some people of US versus Kirby. This is a Supreme Court case from 1868 in the United States. What happened was a sheriff was charged with interfering with the mails, which was a federal crime, when he arrested a murder suspect who happened to be a mail carrier and was doing his job. The suspect was doing his job at the time. So locally, you have to understand a little bit about the American legal system, that there's the federal law, and then there's the state law, and there's local law. So acting under state law, this sheriff arrested this guy who was suspected of murder. It just so happened that this guy who was suspected of murder was a mail carrier for the US Postal Service, which was, coming under federal law. So he was charged with a crime under federal law of interfering with the mails because he interrupted him while he was doing his job. So the Supreme Court decided unanimously that applying the law against Kirby would be absurd, and that all law has to be interpreted so as to avoid those absurdities. And therefore, in order to avoid the absurdities, the law has to be understood in terms of the contemplated function that the law was to serve, right? So what was the point of the law? Trying to understand what the point of the law against interrupting the mails or interfering with the mails would be a way to understand why Kirby wasn't guilty of that, having done that, right? Okay, fine, no problem. Good case, probably a good decision. The thing that I think as a legal positivist, we always want to try to remind ourselves, if we're on that side, as I explained before what legal positivism was, that's the idea that law is just the institution we make it, is that, in many of these, especially high court cases, there were arguments on both sides, and the other side could have won, right? I mean, it just so happens in the American legal context, he wasn't guilty of interfering with the males. But you could imagine a parallel legal system of another kind, maybe with exactly the same laws, and the Supreme Court in that parallel legal system says, no, the sheriff was guilty of violating the laws. He can still arrest the guy guy can go on trial for murder, but I'm sorry, he still has to go on trial he's still guilty of interfering with the male. So if that's true, if a Supreme Court can always have decided the other way, that's a very important thing to keep in mind for what we can learn from cases, right? We can learn the nature of interpretation and the nature of legal meaning and where it comes from these cases, but we can't use any given decision to learn something about the nature of law itself. I think that's a very important point. So the relevance of the law's function or purpose to understanding its meaning is a normative move and not an explication of law's nature or our concept of it. What do I mean by that? Well, if you look back at the Kirby case, understanding that there could be a parallel legal system in which the Supreme Court could have decided the other way means the very understanding of the use of function or purpose to understanding the meaning of the legal text is itself up for grabs. We may need to use it and we may not need to use it. That's a question for that legal system to decide. And it may be something that you have to have a debate about. And, theorists are going to have their own opinions about that. So it's not in the nature of law that you must use the function or purpose of the law in order to understand its meaning. That's just true in some legal systems, or it might even just be up for grabs. You sometimes do it and sometimes don't, and some people are going to fight for one side and fight for the other. So the only general truth maker for any legal proposition is whether the status it represents has been accepted or internalized by the right audience, right? The only truly general truth maker for any legal proposition is whether the status that it represents has been accepted or internalized by the right audience. Maybe as if internalization works too. We don't know. I have to come back to that. Then even questions such as whether judges discover the law, by which we mean they don't make it up, they are just interpreting what's already there, or create it when deciding hard cases, are answered on a system-by-system basis by looking at what criteria legal meaning have been accepted. What criteria of legal meaning have been accepted in that legal system, right? So there isn't an easy answer to the question of whether judges discover the law or create the law when they're deciding these hard cases, because that's going to be done maybe on a system-by-system basis in terms of how much they think they can get out of the legal text versus how much they have to create their own interpretation or bring their own understanding to that. The problem is that may look correct, but since their uptake, that is the judge's uptake themselves, is doing the truth making, right? It's their uptake that is constitutive of the legal meaning of the texts. Then from an external perspective, and it's really important to understand this external perspective that is outside the legal system, not looking at it from inside the legal system, but looking from an outside perspective, we must be saying that the judges cannot be discovering the law and they must be constituting it with their decisions. So within the system, you can have this debate between constituting the law by making the decision versus discovering it. It was already the meaning of the text when you said what it was. That's true of within the system. But once you're outside the system and looking in on it, it has to be the case that they're creating the law by making their decisions, because that's the uptake. Their uptake is constitutive of legal meaning in the same way that the uptake is constitutive of legal status. Legal meaning is a part of legal status, right? Now, this might be one reason that interpretivists like Dworkin fight against external perspectives. But I don't see how you can really deny that external perspectives are taken all the time, not just by legal theorists, by cultural anthropologists and sociologists and anybody who's studying this stuff kind of in a systematic scientific way are taking a kind of external perspective on it. And therefore, from that point of view, which is one in which if you're trying to understand the nature of something, you're usually trying to get outside of it in order to understand that nature. From that point of view, it seems like you have to say that their uptake is creating the law, that it's not determining the law. This is why I say be careful whom you tell, right? So this isn't meant to be an argument against legal anti-positivists like Dworkin, but rather it's one way, if this is one way in which they are incorrect, because if it's an argument against legal anti-positivists, I beg the question really, because I'm kind of assuming the truth of that about the external thing. But rather, if this is one way in which they're incorrect, then we can use this fact to say that there can't be any good legal reasons for the uptake of legal status, right? There can't be legal reasons for the uptake because then you would be inside already in order to have those legal reasons. So any good reasons we do have are also not thereby rendered legal reasons. Any reasons we do have for kind of accepting upon ourselves the uptake are not legal reasons. And the only good reasons for that uptake are likely to depend on whatever legitimates legal authority, right? So whatever reasons we'd have for, these are antecedent reasons, non-legal reasons, right? Moral reasons, if you will, reasons that come from rationality, those that's gonna be the source for any reasons we have for accepting legal authority. So those are non-legal reasons. You can't use legal reasons to say why I should listen to the law. You have to have a non-legal reason to understand why you need the law. Now that's where I concluded this paper. I'm not satisfied with where it ended up. I think it's still very much a work in progress, as I said. I think there's more potential for developing a discussion here about, maybe you can help me with this in the Q&A, about this whole thing about the perspective, the external perspective, and the fact that you can't really deny that the judges are creating the law when you look from the external perspective, and what the implications that are about that for, as I said in the title, be careful whom you tell. The intuition that I was trying, and this is the last thing I'll say, the intuition I was trying to go for there was, you know, there's a way in which by telling people, I didn't really get to this in the paper, but by telling people that their uptake is really constitutive of legal status, you risk the security and the impact that status has. It seems like, you know, we as philosophers can discuss this, but if we made it widely known that everybody's uptake, that none of this is real, and I mean, you could kind of see things happening a little bit with this whole understanding that everything is socially constructed, right? Now, some people understand that the fact that it's socially constructed doesn't make it any less real, but a lot of people who believe in this social construction of reality type of understanding tend to see, therefore, that the realities that they have therefore socially constructed have somehow less impact or have less normative sway as a result of that, or less reality as a result of that. So that's the kind of intuition I was saying with be careful whom you tell, but I was also thinking that maybe we have to be careful about how we discuss that with legal anti-positivists, partially because they'd probably deny this whole external perspective, but maybe we can talk about that more in the Q&A. Thanks for your tolerance. I know this isn't the clearest paper, so I do appreciate your time and your forbearance.